What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury.
It is not the Commonwealth putting on a circus or a parade. It's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children and the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean
the potential harmful and everlasting emotional impact to Mr. Clancy and his family of any public dissemination of such graphic and sensational evidence and exhibits related to his 3 children is immeasurable. That sentence appears on page 3 of a motion filed in Plymouth Superior Court on July 20th. The father of the 3 dead children is begging the judge to shield certain pieces of evidence from the public eye. Yet inside the same courthouse, just days before opening statements, the prosecution and defense are locked in a war over how much of that very horror must be paraded in front of a jury, and one side is calling the other's strategy a circus. The document asks for restraint. The courtroom is demanding the opposite. Picture a snowman in a front yard on Summer Street in Duxbury, Massachusetts. It was built on the afternoon of January 24, 2023, by a mother and her 3 children. By nightfall, floodlights from cruisers and ambulances would melt the snow around it as first responders discovered what no training exercise ever prepares you for. That snowman stood frozen, its coal eyes facing the house, long after the children who built it were gone. Before we go deeper into what the documents actually show, make sure you're subscribed to Crime Files 9/11. Because we don't just cover the story, we follow the evidence. The clash that erupted in the Plymouth County Courthouse this week was not about whether Lindsay Clancy killed her 3 children. Her defense team has already conceded that point. The fight, raw and unfiltered, was over what the jury would be forced to see and hear, and whether the state intends to try a murder case or stage a spectacle. Defense attorney Kevin Reddington did not mince words. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions of the jury. He accused the Commonwealth of wanting to parade 17 first responders to the stand, one after another, each describing in graphic detail what they found in the basement of 47 Summer Street. He argued that the defense had repeatedly stipulated to every piece of evidence the prosecution wanted to admit, making the emotional procession legally unnecessary.
All of this was the precursor for Reddington's motion, asking the Commonwealth to limit the number of first responder witnesses they plan to call.
This motion is asking that Your Honor would direct the Commonwealth, since apparently the Commonwealth will not agree voluntarily to restrict the presentation of a large number of first responders to this tragic incident. First of all, let's face it, firefighters, EMTs, police officers, they're all wonderful people. They're doing the Lord's work. What these people have gone through or would go through and have gone through in their jobs cannot be underscored. And that's to be respected and embraced. But to present them one after the other in this trial to testify to, and I would very briefly, I don't even have to mention their names, but Duxbury Fire Department paramedic detailed to the home at 47 Summer Street dealing with the defendant, Lindsay Clancy, treating with her outside with her injuries. The Duxbury Police Department sergeant went to the house, heard noises. Stephen Hall, there's a Duxbury Police Department officer, saw the defendant, heard screaming in the basement. Duxbury Police Department heard another individual, heard screaming in the basement, went in, saw the kids in the basement.
We stopped the soundbite there, but Reddington goes on to list 17 different first responders from various agencies, all on the Commonwealth's witness list.
So that was what was presented to the grand jury, and is what, from what we can see, is what the government would try to present at this trial. And I suggest to the court, without sounding as though I'm trying to minimize the horror of what transpired here, and what these good employees of the municipalities had to endure and see, and probably to this day are suffering post-traumatic stress from it. Legally and objectively, I suggest to Your Honor that it serves no purpose other than to inflame or try.
The prosecution fired back with a statement that cut through the legal posturing and landed like a verdict. The Commonwealth did not choose the number of victims. The defendant did. The Commonwealth did not choose the ages of the victims. The defendant did. The Commonwealth did not choose the horrific nature in which they died. The defendant did. Assistant District Attorney Jennifer Sprague then posed a question the defense could not answer. If defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter, she Googled the restaurant. That single act, documented in the digital forensics report entered into the court record, is the fulcrum on which the entire case will turn. At approximately 4:00 p.m. on January 24, 2023, Lindsay Clancy searched for the 3V restaurant in Plymouth and looked up the driving distance from her home. Prosecutors will argue she was calculating the window of time she would have to complete the killings while her husband Patrick was out picking up dinner. The defense does not dispute the search happened. They dispute what it means. They say Lindsay was in the grip of a psychotic break, commanded by a voice that told her, "This is your last chance. Kill the children so you can kill yourself." They say she watched her own body carry out the acts as if from outside herself. The Google search, they imply, was a mundane chore, not a countdown timer. To understand why the pre-trial hearing reached such a fever pitch, you have to go back to what the Commonwealth of Massachusetts requires when a defendant raises a lack of criminal responsibility defense, what most people still call the insanity defense. Under Massachusetts General Laws Chapter 278, Section 33B, the burden is not on the defendant to prove she was insane. The statute is explicit. There is no burden on the defendant to prove that they lacked criminal responsibility. Instead, the prosecution must prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged offense. That means they must demonstrate that Lindsay Clancy had the substantial capacity to conform her conduct to the requirements of the law, and that any mental disease or defect that may have existed did not deprive her of that capacity. In plain English, the Commonwealth has to convince 12 jurors that, despite a documented history of severe postpartum depression, a diagnosis of bipolar disorder, a recent psychiatric hospitalization for suicidal ideation, and a regimen of up to 13 psychotropic medications, Lindsay Clancy was still able to obey the law when she tightened the exercise bands around her children's necks.
Against Lindsay Clancy. She faces 3 charges of murder brought by the Commonwealth for the deaths of Cora, Dawson, and Callan. The defense has long opposed these charges, but is now ready to fight using the lack of criminal responsibility defense. Now, this is most commonly known as the insanity defense, meaning the defendant says they're not guilty by reason of insanity. But that's not exactly how it works here in the Commonwealth of Massachusetts. This is straight from the Commonwealth statute. It reads, if the Commonwealth has proved the elements of the offense beyond a reasonable doubt, the Commonwealth must also prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged offense. Under the law, a person is not guilty if they lacked criminal responsibility when they committed the offense. This is sometimes referred to as not guilty by reason of insanity. There is no burden on the defendant to prove that they lacked criminal responsibility. So that means zero burden on the defense to prove that Lindsay Clancy had a mental disease or defect. In fact, it's all on the burden of the Commonwealth to prove that despite any sort of diagnosis, that Lindsay Clancy was criminally responsible at the time of the murders. The statute goes on to specify, to establish that the defendant had the substantial capacity to conform their conduct to the law's requirements, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed at the time of the alleged offense did not.
The jury questionnaire, a copy of which was obtained from court records, reveals just how delicate this task will be. Potential jurors were asked, is there anything about this so-called insanity defense that would offend you, or because you do not be able to fairly decide this case? They were also asked whether they, a family member, or a close friend had ever been diagnosed with postpartum depression, generalized anxiety disorder, or bipolar disorder. The form sought to expose whether any experience with mental health professionals would make impartiality impossible. During individual voir dire conducted just inches from Lindsay Clancy, who remains confined to a wheelchair after jumping from a second-story window and severing her spinal cord on that same day, multiple prospective jurors broke down crying.
For a week, it was simply jury selection and a few motions hearings, and yet I saw multiple people crying, 3 yesterday alone. And here's what's staggering. As potential jurors were called to individual voir dire, they were just inches from Lindsay Clancy herself. I heard multiple prospective jurors saying things like, quote, I'm a mom and I just can't. I saw people bringing literal boxes of tissues to voir dire crying in front of Lindsay Clancy herself, something I've never seen before in jury selection. Now, on day 2 of all of this, there was some additional drama when a previously seated juror came forward in front of both the judge and the Commonwealth and the defense. And let me tell you, he was emotional. He was loud. I even could hear him over the white noise. And this is what he said. It's a direct quote. I just don't know if I can handle being on the jury. I've just heard about it, and a crime like this is really just horrible. I don't think I can handle it. And mind you, all of this is said just inches from Lindsay Clancy.
One seated juror had to be removed after stating, "I just don't know if I can handle being on the jury. I've just heard about it, and a crime like this is really just horrible." By the time the panel of 18, 12 jurors plus 6 alternates, was finally seated, composed of 12 women and 6 men, the emotional toll on everyone in the room was already visible. The motion filed by Patrick Clancy, represented by attorney David Meyer, did not ask to close the courtroom or to exclude evidence from the jury. It requested a far narrower remedy that certain evidence be impounded, meaning not released to the media or public, including the 9/11 call Patrick made when he returned home, autopsy photographs, the clothing the children were wearing, and material Patrick himself had provided to both sides. The motion argued that the harmful and everlasting emotional impact of public dissemination was immeasurable.
Of Patrick Clancy, the father of the 3 child victims in this case, he recognizes, and I recognize on his behalf, that he has no authority, no standing, and no intention of suggesting to this court or to the attorneys how to try their case, how to conduct direct or cross-examination, and perhaps most importantly, what evidence or exhibits should be introduced during the trial. Mr. Clancy, respectfully, Judge, is not seeking to close the courtroom at any time during the trial. Mr. Clancy is not seeking to address the admissibility of any evidence or to exclude any evidence from the jury. And he's not in any way seeking to prejudice the Commonwealth or the defendant in any way. What Mr. Clancy is seeking through counsel, Your Honor, respectfully, is to restrict in a very limited way the display and access to certain specific limited items of evidence and exhibits at trial to the jury, to the court, to counsel, to the court reporter, to the session clerk, and to the court officers. That is, the necessary parties who will be involved in trying the case. And I respectfully, Judge, I suggest that pursuant to the so-called Massachusetts Victims' Rights Bill and other statutes and cases with which the court is familiar, as a victim, as a family member of the 3 victims in this case, Mr. Clancy respectfully has an opportunity.
During the hearing on that motion, the defense seized the moment to launch its broader attack on the prosecution's trial strategy. Reddington called it reprehensible that the government intended to place Patrick Clancy on the witness stand and show him the clothing his children died in, items he described as little onesies with bodily fluid of his child. He pleaded for what he called a little bit about humanity.
Hence.
But I still want to say that I think it's reprehensible the way the government is trying this case.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away what happened, and focus on something else.
Here's what we're going to do. We're going to end that now, all right?
So he gets an opportunity to say it.
The judge, William F. Sullivan, tried repeatedly to steer the argument back to the narrow question of media access, but the fuse was already lit.
When it's time for the Commonwealth to respond, things get tense all over again.
Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself, who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
The prosecution's response was surgical. They noted that the first responders who arrived that night thought they were responding to one victim, Lindsay Clancy herself, lying injured outside the home.
Alone. Either he would stay with her and the kids or a family member would come and do the same. But that's not what happened on the day of January 24th, 2023. That morning, Lindsay Clancy's oldest daughter, Cora, was having some stomach issues, so Lindsay took her to the doctor for an appointment. When they got back, Lindsay and the kids played outside in the snow. They even built a snowman. Around 4 p.m., Lindsay Googled the 3V restaurant in Plymouth and looked up the driving distance from her home in Duxbury to the restaurant. And this is important, as prosecutors will later argue Lindsay murdered the children with premeditation, making sure that Patrick would be out of the house long enough that she could complete this act without interruption. But according to a lawsuit filed by Lindsay's team, that's not exactly what happened. Yes, she did send Patrick out to get dinner, and yes, she did ask him to run to CVS to pick up something for Cora. But after that, they say she suffered a severe mental break. This is straight from that lawsuit. It reads, as soon as Patrick left to pick up the food, there was a loud, demanding, repetitious voice. This is your last chance. Kill the children so you can kill yourself. Lindsay's team argues she felt a force come over her and started to experience a series of hallucinations. She says she experienced a dreamlike state where she had no choice but to follow the orders of these voices, and then described watching herself carry.
Only after entering did they discover the 3 children in the basement, each with an exercise band still around their neck. They found 5-year-old Cora, 3-year-old Dawson, and 8-month-old Colin. Multiple responders attempted CPR, handing off from one child to another as more personnel arrived. The chaos multiplied the witness count not out of prosecutorial excess, but because of the physical reality of trying to save 3 separate lives simultaneously. The Commonwealth did not choose the number of victims. The defendant did. That line, repeated with controlled fury, left the defense's argument that it was all a circus sounding hollow. She Googled the restaurant.
Don't need that.
Lindsay Clancy herself was so overcome with emotions during these arguments, by the way, that she began crying. The judge made note of this motion, but ultimately decided it was too early to rule on anything definitively.
I guess probably just so you be prepared that the defense objection will be it's cumulative. And we come over here, and if there's some reason why there's something else that this witness brings or a reason why you want to call him, then we'll deal with it at that point.
The Commonwealth will be prepared.
All right. So I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate the parties raise. This is exactly why we have motions in limine, so I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is, so I'm kind of ready for that as well. So I'm not going to take any action on that.
Court is dark on Friday, but opening statements are expected for Monday. And I've been told by Kevin Reddington himself that the first witness is expected to be Patrick Clancy. He'll be called by the Commonwealth as their star witness, but also will be questioned by the defense under special circumstances, meaning it will be more than just cross-exam, but the ability for the defense to put on their case a little bit early.
Here is the question that transforms this trial from a tragic headline into a legal thriller. If the prosecution can prove that Lindsay Clancy checked the drive time to the restaurant before sending her husband away, and if that digital timestamp aligns with a window of opportunity, does that single search prove she understood the wrongfulness of her conduct at the exact moment the law requires? The Massachusetts statute says a person lacks criminal responsibility if a mental disease or defect deprived them of the substantial capacity to conform their conduct to the law. A Google search for a restaurant's distance does not, by itself, negate a psychotic break. The mind can perform rote tasks while fragmenting in other domains. The prosecution will argue it demonstrates planning. The defense will argue it proves nothing about her mental state when the voice allegedly took over. The jury will have to decide whether a woman who could still use a smartphone was also a woman who could obey the law. The pre-trial hearing ended with the judge declining to rule immediately on the motion to limit first responder witnesses, noting that objections could be raised as the trial unfolds.
When it's time for the Commonwealth to respond, things get tense all over again.
Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself, who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to one victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did. The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children and the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
Opening statements are scheduled to begin, and the first witness called by the Commonwealth is expected to be Patrick Clancy himself, a man who, according to his own legal filings, has already suffered one of the worst tragedies any human can endure, who has since divorced Lindsay, remarried, and tried to rebuild some semblance of a life, and who will now have to sit in a witness box and describe what he found when he came home with the takeout order his wife had asked him to pick up. She Googled the restaurant. The motion to impound, filed on July 20th in Plymouth Superior Court, is a public record. We have posted a link to the full document in the description. Read the list of evidence Patrick Clancy wants kept from the cameras and the public. Then tell us in the comments which piece of that evidence do you believe the jury must see in order to reach a just verdict, and which piece, if any, should never be broadcast. If you believe that justice follows the evidence and not the emotion, like this video, share it, subscribe to Crime Files 911, and turn on notifications. We'll be tracking every exhibit as this trial moves forward.